Hello friends, I welcome you to our series on rights issues. Now this is going to be a continuation of the last video where we spoke about the definition of a refugee. We spoke about the different criteria that leads to determining an asylum as a refugee. Then we also spoke about the history of the 1951 Convention, how it came from the League of Nations and the International Refugee Organization. Then, moving on, we spoke about how the most powerful policy in all of this is the non-refoulement policy. जिसका मतलब है अगर a person who's seeking a refugee from the place where he's prosecuted, he's coming from a country of prosecution and he has entered the borders of a safer country, then this country cannot expel the person back. वो उसको धक्का मार के दोबारा वहाँ नहीं भेज सकते जहाँ prosecution हो रहा है. They can't do that, right? And then finally, we spoke about RSD. What was RSD? RSD meant refugee status determination. RSD means that the contracting state, the state which has signed the 1951 Convention or the 67 Protocol, the onus lies on this country to determine the person who has come seeking asylum is going to be called a refugee or not. Bearing in mind that the guidelines are set by UNHCR to determine if this person is going to be a refugee or not. Guidelines, UNHCR, who is determining? The state, right? So that was RSD. Now, in today's video, we are going to talk about India's own policy when it comes to the refugee, the whole idea of refugee, the whole idea when a person is entering the Indian borders, and the whole idea of a foreigner, right? So let's jump right into our class. Now, if you look at the system in India, it is going to be a dual system. Why is it a dual system? Well, in India, there are two bodies which are defining what is happening to a refugee. The first body is the UNHCR and the second body is the Indian government. Right? Now, why is there a distinction here? The distinction here is because India is not a signatory to the 1951 Convention, but it has allowed UNHCR to set up its own offices in India under a Memorandum of Understanding. Now, इस Memorandum of Understanding में India ने बोला UNHCR को कि you have the right to determine who is going to be a refugee in all countries that are not bordering countries to India, which means all non-neighboring countries, non-neighboring countries and Myanmar. Any person who is coming into India from non-neighboring countries and Myanmar would be under the RSD of UNHCR. UNHCR will define the refugee status for these people. And because of this, they are known as mandate refugees. Let's look at the examples of this. One good example here would be the refugees who are coming into India from Afghanistan. Now, Afghanistan has had a turmoil. They've had a very troubled history. Be it the Soviets coming into Afghanistan, be it the fall of the Najibullah regime, or be it now that the Taliban has taken over, or the Taliban war that has been going on. So there has been a regular influx of Afghanis from Afghanistan into India. Now, for these people, India said that all these people who are seeking asylum to go to UNHCR. UNHCR will give you the refugee status, whatever they have to give under their own refugee rights laws and convention that was signed in 51. We are not going to do anything about it. Same thing happened with Iranians. When the Shah regime fell in 1979, at that time, there were a lot of Iranian students in India who were here for, be it studying in universities. There were a lot of tourists in India. There was a continuous influx of Iranians into India, be it for medical tourism or tourism. So in this case, the moment the regime fell in 1979 and Ayatollah Khomeini took over Iran, these people expressed concern. They said कि अगर हम अब वापस गए तो हमारे ऊपर prosecution हो सकता है. And this is the reason, I remember in the last video we spoke about this particular term called refugee surplace. This was the case of refugee surplace, where they had entered into India with valid travel documents, but now they were in a position where they cannot be returned back to their own country. Later on, UNHCR granted them a refugee status under their own rules, right? Similar thing has been happening with Iraqis, Sudanese, or Myanmar people, right? And then who are these non-mandate people? The non-mandate people are the people who are given protection by the Indian government. Protection by the Indian government. Now, if they are given protection by the Indian government, they don't have a requirement to go to UNHCR. If they are being provided all the assistance by the government itself, they don't need a third party here. Now, it'll be much easier to understand it if you look at the examples. The first example is the partition that happened in 1947. Now, during the partition of 1947, there was a huge influx of people from both sides. India was taking in a lot of people who were coming from Pakistan. And remember, this was happening in 1947, so there was no 51 convention back then. So back then, the whole terminology of a refugee did not have a very official meaning to it, right? So back then, India called these people forcibly displaced persons or called them evacuees. अब इनके लिए इंडिया ने जाके legislations बनाया. India made legislation for forcibly displaced people. India made legislations for rehabilitation of these people. In fact, there was a time where India created a separate refugee ministry so that rehabilitation of all these people can be done throughout the state of India. Right? Throughout the state of India that could be done. So this protection was granted by Indian government himself. And because Indian government was granting this protection, even before this convention came in, we were well within our rights to be considered one of those countries which are exceeding their own human rights needs and providing help to other people, right? Similar thing happened when Tibetans came in. When in 1959 there was a huge influx of Tibetans when His Holiness Dalai Lama came in and India granted them political asylum. In this case, what happened? India said even if these refugees who are coming from in Tibet, they don't have valid travel documents, we will give it to them. India made rehabilitation laws for Tibetans and then made sure that these Tibetans get resettled into India, be it Karnataka, be it in Himachal Pradesh, in any of these places. Same thing happened during the 1971 Bangladesh war. There was a large influx of Bangladeshis from the in and around the bordering states. And later on, when India recognized Bangladesh as a country, as an independent country in 6 December 1971, India signed a bilateral exchange of refugees agreement. India said that all these refugees will be repatriated back into Bangladesh. But during that time, some Bangladeshis decided to stay back. And India, being a very humane country, being a country who was respecting all these human rights, gave them the opportunity to stay back. But later on, as we know, that this created this whole outsiders problem in Assam, and then there was the whole Assam Accord. If it's something that you want me to make a video on, let me know in the comments below. And then later on, same thing happened with Sri Lankans. When Sri Lankans were fleeing this ethnic conflict that was happening between the Sri Lankan Tamils and the Sinhalese people, India back then also was granting them refugee status, was granting them asylum, was granting them different camps in neighboring states from where Sri Lankans were coming to have a place where they can be rehabilitated and resettled. And later on, if there was a possibility of voluntary repatriation, that could be done. So, a clear distinction can be made here, where there in one side we have the mandated UNHCR mandated refugees coming from all the non-neighboring countries in Myanmar, and we have the mandated countries here, and we have the non-mandated countries here, which is from the bordering countries of India. We have the mandated refugees coming in from the bordering countries of India, right? Now, this distinction later on, when we look at it in the Constitution of India, we see that the Constitution of India, when it comes to refugees, is very liberal. Just as liberal as the government has been all through these years, the Constitution itself is the provider of that being liberal, right? The Constitution says, Constitution हमें बोलता है in Article 21 that no matter who's entering into India, the Article 21 says that the right to life and liberty will be given to no matter who's entering India. In that case, it doesn't matter if it's an illegal migrant, it doesn't matter if it's a migrant, it doesn't matter if it's an alien, a non-citizen, a foreigner, or a refugee. Everyone will be given the same baseline of right to life and liberty, right? Same thing happens with Article 51. Article 51 says, under our directive principles of state policy, that India is going to respect international laws and treaties. And then by the virtue of Article 51, we move on to Article 253, which says that the Parliament has the power to make any law for whole or any part of the territory of India to implement any treaty, agreement or convention. Which means the Constitution is already liberal enough the constitution is already liberal enough to let anyone come in and enjoy the right to life and liberty, which is the minimum standard set by the 1951 convention. So from both these examples, as we see, from the treatment of these non-mandated refugees and from what the constitution says, we see that India has already been a liberal country when it comes to the refugee policy. From the influx of refugees, doesn't matter how much pressure it's creating to the infrastructure of India, doesn't matter how much demographic changes are happening, India has still gone ahead and done much more and much beyond its own human rights needs when it comes to the rehabilitation, resettlement, and for the betterment of the refugees, right? But if that is the case, then why has India not formulated a refugee policy? This is something which we'll see later on in this video. But before that, if you look into the legislations that prevail in India that direct what is happening to a foreigner, it is mainly these three legislations. And after that, we'll speak about this legislation, which is the Citizenship Act. There's a very curious case here. Now, the first legislation we're going to talk about is the Passport Act. The Passport Act of both 1920 and 1967, simply, you don't have to go ahead and mug up the Passport Act. You just have to understand what it says. It says that India is going to grant the passport. It's going to make an authority which can grant the passport. And this passport is going to be a valid document for anyone entering or leaving the country. Right? This passport is going to be a valid travel document. Right? Now, see, in Article 27 and Article 28 of the 1951 Convention, it says that the state which is taking in refugees, it is the responsibility of the state. वो इस state का responsibility है कि वो इन refugees को एक valid travel document दे अगर इनके पास नहीं है. India has already fulfilled it. India has already fulfilled it in its own Passport Act, right? Then comes the Registration of Foreigners Act 1939. In that, simply it says it will give you a procedure for foreigners to report to a prescribed authority about their presence, movement, departure, and proof of identity. So, पहले हमारा Passport Act, which talks about who's going to, you need a valid travel document to enter, you need a passport to enter. Then the Registration of Foreigners Act, which talks about the presence, movement, departure, and proof of identity. तुम कौन हो, तुम कहाँ जा रहे हो, ठीक है. पहला वाला is तुम यहाँ आ रहे हो तो कैसे आ रहे हो, how are you coming, do you have a passport. Second one is about the presence, movement, and departure of and proof of identity. And then finally, the all-powerful Foreigners Act of 1946. Now, this law talks about how these laws are applicable to all foreigners in general, but this is the law that India has always been used to safeguard the policies that is regarding refugees who are coming into India. The Foreigners Act says that India, as a government, has the authority to expel anyone who is coming into India, which means, if anyone is threatening the security of India, if India feels that anyone who has entered, doesn't matter if he's seeking a refugee status, doesn't matter if he's an illegal migrant, India has the right to throw them out of the country, right? And in fact, implicit in this Foreigners Act, it says that India can use force, reasonable force can be used by India, or punishment can be given, imprisonment of up to 5 years can be given if a person is not abiding by the Foreigners Act of 1946. So India has always wanted to have this right within itself, कि I get to choose who is going to come into my country, who is going to stay in my country, and who I get to throw out. ठीक है? So we see that slowly, all these things are telling us why India actually did not sign this convention. And before we move on to those reasons, let's look at what sort of a question can UPSC ask. Now, UPSC can ask you that India has not signed the 1951 convention. Then, because if India has not signed the 1951 convention, can the UNHCR still grant refugee status to a refugee? The answer is yes. The UNHCR can grant the refugee status to who? The people who are from non-neighboring countries and people from Myanmar. But isme, like, that is the answer that you will give to UPSC. But between your understanding and what I'm telling you here, you have to understand this refugee status that UNHCR is granting doesn't mean a lot. अभी क्या हुआ था जब Rohingyas came in after they were declared stateless by Myanmar, when they were coming into India said to UNHCR कि ठीक है तुम लोग इनको दे दो refugee status, अगर तुम लोग को देना है तुम दे दो. And later on, India said that Rohingyas are a threat to national security, so I want all Rohingyas to be thrown out of India. Here, it didn't matter if UNHCR has given them the refugee status or not. It didn't matter because India, like I said, under the Foreigners Act, it gets to decide who it wants to keep in and who it wants to throw out. Now, here, an interesting case here is that the Citizenship Act of 1955, which was amended in 2019, cannot be considered a refugee policy. Why have I categorically written this here? The reason why I have categorically written this here is because जब ये 2019 का policy आया, उस time पे it said that India is going to allow illegal migrants from the 3 neighboring countries of Bangladesh, Pakistan and Afghanistan belonging to 6 religions, Hindu, Christian, Sikh, Jain, Buddhist and Parsi, right? They are going to allow these 6 people from these 6 religions from these 3 different countries to be registered as legal migrants, to apply for citizenship. Now, in nowhere does it talk about that, even though they say that these are religiously persecuted minorities in these countries, यहाँ पे it never says that these are refugees whom we are granting a citizenship. Because there's a cut-off date. There's a cut-off date of 31st December 2014. Because of that cut-off date, doesn't matter anyone from these religions comes after 2014. They can be seeking refuge, they can be prosecuted in all these neighboring countries and come here after 2014, of 31st December 2014, and they cannot seek refuge based on this CAA 2019. And that's the reason why CAA cannot be considered a refugee policy. Right? Now, moving on to the whole question, why India did not sign the refugee policy? Why did it not become a signatory to the 1951 convention? The very first reason why India did not become a signatory to the 1951 convention is because it has porous borders. Now, what does porous borders mean? Well, porous borders mean, remember we spoke about how in Foreigners Act, India wants to have the right to throw away people whenever it wants, or like expel them out. It could be for security reasons. It could be for reasons where the infrastructure is being threatened or the local minorities are being threatened. It could be any other reason, but India wants to have this. Why? Because India has porous borders. What does that mean? Well, the whole border of India is not as securely protected as any other developed country. It is not surveilled throughout, and because of this reason, it is very easy for, suddenly if there is a problem in a neighboring country, if there is a war breaking out in Bhutan, there is a war breaking out in Bangladesh, there is a war breaking out in Pakistan, there could be a sudden influx of people coming into India. Same thing is happening right now when there is a economic crisis happening in Sri Lanka and people have already started coming in. Now, in this case, because the borders are so porous, people can come in and go the way they want, and India doesn't have the infrastructure to oversee these people coming in. This is the reason why India said that I don't want a third party telling me what I want to do when I can have this solution bilaterally. This is also the reason why none of the South Asian countries are part of the 1951 convention, because they know that they have porous borders. They know there has been a historical movement between people in and out of these borders. That's why India has always wanted to keep this decision to itself. I know I have porous borders. I know there is exchange happening, and I want to do this bilaterally. I don't want tomorrow, if there is a sudden influx of people, I should be in a position where I can send them back with all their rights, but repatriate them back into their country. So because of porous borders, that's the first reason why India did not want to be a party to the 1951 convention. The second reason why it did not want to be a party of this convention is because it says the definition of refugee in the 1951 convention is very narrow. Why does it say that? Even though the definition covers a fear of prosecution against race, religion, nationality, it talks about a particular social group as well as political opinion. India says, what happens to poverty? What happens to deprivation? One of the biggest reasons why people are escaping out of their own countries. Look at Africa, look at most of the African countries, look at the European countries. In any of these countries, you would see most of the people who come out of their own country, they leave their own country is because they don't have money. There is no way they can provide for themselves in that country. There is an economic crisis in that country. There is abject poverty in that country and they are escaping out of that. India says your refugee definition does not even provide for something like this. This is one of the biggest reasons why people move out. Refugee definition doesn't provide that. Refugee definition doesn't even provide for when there is internal conflict and violence. It doesn't provide for a situation where there is sudden war breaking out inside the country. There's sudden conflict, there's sudden rioting breaking out and people wants to escape that. Because they themselves might not be prosecuted as a group or as an individual. But just because of that, there could be very legitimate reasons why their life is being threatened because of all these problems. But yet, because these are not being covered into the definition of refugee, India says, I'm not going to sign it. I have already done so much. I have already done, even when your definition was narrow, I took in people in my country when there was crisis happening in all these countries. In fact, India is doing that right now. India is providing whatever aid it could to the people who are coming in from Sri Lanka, right? And this is something that is not covered under the definition of refugee. Then the third reason why India said that it is not going to sign this is because India said my sovereignty might be threatened in internal matters. Now, what does that mean? There could be a very peculiar situation where, let's say, India signed that agreement, and then a miscreant in Kashmir who is claiming to be a Kashmiri says that I'm a refugee, right? The miscreant says that I'm a refugee in India. Now, what if UNHCR goes ahead and gives him the refugee status? That means UNHCR suddenly recognizes that this person has come from a country called Kashmir, right? He's come from a country called Kashmir and now he's seeking refuge in India. By doing so, they are calling Kashmir a separate part. And by doing so, they are threatening the sovereignty of India. This is just an example, but you have to understand that India always wants to be able to define its own matters by its own self. It doesn't want a third party. It doesn't want a third leg into their own workings. India has always said that all our refugee dealings will be through bilateral means. We don't want it to make multilateral. And one of the reasons cited there was the threat to sovereignty. Then, the next reason why India rejects UNHCR's perspective is because its perspective on rehabilitation. Most of the time, what UNHCR wants is that whatever people, जितने भी लोग हैं जो influx होके तुम्हारी country में आए, तुम उनको rehabilitate कर लो, तुमको re-assimilate कर लो, तुम अपनी ही society में उनको ले लो. But India, which has a population of over 1 billion, where infrastructure is already being stressed, and ऐसा तो है नहीं कि जैसे border में enter करते हैं ये लोग equally disperse हो जाएंगे. They would initially go to bordering states, they would go to bordering cities and towns, all the refugees that are coming in, and rehabilitating them in and around that place is not possible. India, in fact, always has been an advocate of, they want voluntary repatriation to happen. They want people to go back. Once the situation in their country is okay, they want these people to return back. But UNHCR doesn't see it that way. UNHCR will always talk about rehabilitation. कि तुम ये लोग asylum seekers आए हैं, इनको refugee status देके इनको यहीं रख लो, इनको अपने सारे rights दे दो, इनको अपने सारे economic opportunities दे दो. अरे that is the reason why we have such an issue happening in Assam right now, right? It could be a threat to the demography. It could be a threat to the community there. You don't want the main community in these states, especially in the northeastern states, suddenly because of an influx, become a minority there. The majority community suddenly becomes a minority community, right? Then it says that the constitution is already liberal. The Indian constitution is already liberal. The Indian constitution has already provided all these rights. The minimum standards that is being set by the 1951 convention, it is already being provided by the constitution. Constitution has already provided for all the refugees, be it illegal migrants, refugees or IDPs or whosoever is coming into India. They are all being treated on par as non-citizens, aliens or foreigners. They are all being treated at the same level. So if the constitution is already liberal, the constitution itself, the law of the land is already granting them the status where they are not being alienated they are not being alienated from the right to life and liberty, then why do we need to sign a piece of paper that says that we are doing that, right? And then finally, we see that India says the West should share the burden as well. Now, this is something that we saw in the first video. We saw that 86% 86% of the burden of refugees is being borne by developing countries. And developed countries are doing only 14% of it. But जितना शोर शराबा जितना हुआ मचाना होता है वो लोग ये लोग मचा रहे हैं. ये 14% are doing this whole hue and cry about why is India not having a domestic refugee policy. Arey, you look at the burden that you're sharing. You being one of the biggest economies, suddenly you're saying that India should do it when you have such huge deportation laws. You are creating walls in your borders so that people cannot enter you, right? And look at the skewed reporting. The moment the Ukrainian war happened, if you look at the news that was coming out of these places, especially this Western media, they suddenly started comparing and saying that the Ukrainian refugees are not like Syrian refugees. They are people from our own community. Can you see the racial bias that is happening here? So India saw this racial bias where only 14% of burden is being borne by the Western countries. India says that you first stop being a hypocrite and start sharing the burden of refugees yourself. And then you point the finger at me. Right? So these were the 6 reasons why India said that I'm not going to sign, or India hasn't signed the 1951 convention yet. There's a really good book by B.S. Chimini about refugee rights and states and policies, where he talks about these in detail. So if you want me to tell you more about these books, or if you want more sources so that you can read up after the video, let me know in the comments below. Now, finally, to conclude our class on refugee rights, let's talk about why India should have a domestic law. India में एक refugee law की ज़रूरत अगर है तो क्यों है? Now, the first reason would be that it will give them a good distinction. India will have a proper distinction between a migrant and a refugee. Now, what does that mean? What does that do? What it does is that there would be a lot of migrants in the garb of refugees and a lot of refugees in the garb of migrants. There would be a lot of people who are coming in from countries where there is no prosecution, but they'll feign prosecution. वो लोग बोलेंगे नहीं हम prosecuted हैं, मैं एक particular community से आ रहा हूँ and मेरी वो community prosecute हो रही है वहाँ पे, so please मुझे रख लो, मुझे refugee status दे दो. अब in all of this, if India has a particular law which states in much more detail than that, see, the 1951 convention is a generalistic convention. It is a very generalistic convention because it's an international convention. You would see that there are organizations like Organization for African Unity and Organization for American States which have their own regional refugee conventions. Similarly, if India has a refugee law, India will be able to make particular distinctions between who is going to be a migrant and who is going to be a refugee. At that point, no one will be able to point a finger at India, right? So having a particular law to make a distinction between a migrant and a refugee will help them none of these international communities will be able to point a finger, right? The next reason would be to explicitly outline its security concerns. See, now remember, in the 1951 convention, there's a particular exclusion clause which talks about that if the refugee itself who is coming in is a threat to the national security and public order, or has committed certain war crimes, or is escaping a non-political crime, right? He can be sent back. But these can't be the only reasons. So if India tomorrow goes ahead and makes a domestic law, India will be able to outline all its security concerns. In this security concern, it can talk about terrorism. It can talk about how some neighbor countries have certain there are certain people who can come and affect Indian national security and public order in the garb of refugees. So by having a proper domestic law on refugee, India will be able to outline its own security concerns. It will have its own security concerns outlined, and in that case again, the international community won't be able to point any fingers on India when it comes to having a domestic refugee policy, or who they are accepting as refugees or who they are not accepting as refugees. The next reason is to avoid diplomatic problems. What does this mean? A good example of this was Karmapa Lama. The Karmapa Lama was escaping out of China. India gave political asylum to Karmapa Lama. Now China says that this is very wrong. This is a problematic position where we see this as an unfavorable condition where a person we are prosecuting, a person we see as a criminal, how come India is doing this? How come India is giving a political asylum to someone like this? Now, if India has a particular domestic law, then India can say that anyone who's coming into India and India is giving them humanitarian need, in that case, it is a non-political, it is a completely non-political, non-biased decision. We are going to give humanitarian aid to whosoever we want to, and this is not going to reflect in our political stand. By doing so, they eliminate all such problems where someone else can claim ki, how are you giving them a refuge when these are problematic people from our country, right? India is a sovereign country, so India gets to make all these decisions, and by outlining these decisions in a domestic refugee law, they avoid all such diplomatic problems. Up number 4 pe we have, if India makes provisions for cessation of refugee to make provisions for cessation of refugee status with a solution towards voluntary repatriation. Now, if you have a domestic refugee law, you'll be able to say who are the person I'm going to include as a refugee, and who are the person, if having done certain problematic things, will be, from them the refugee status will be taken away. The cessation of the refugee status, right? If you outline this, tomorrow no one can question, be it the 1951 convention or anyone else cannot question why you've taken it, because you've already outlined these provisions, right? And you, in that same law, can have this voluntary repatriation. What does voluntary repatriation means? It means that once, let's say a country is fleeing from Sri Lanka, they've come here, India has given them a camp where India is providing them healthcare assistance, India is providing them economics assistance, India is providing them every single assistance that is required for them to enjoy their life. Whatever is happening, India is giving them, right? But now, let's say after a year or two, the situation in Sri Lanka has gotten a lot better. Life has returned to its normalcy. So now India would like them to voluntarily get up and go to their own country. Because at the end of the day, again, we know that the resources in India is still strained. The resources in India is still limited, especially in camps like these where there will be a large influx of people regularly. So India says that at that point, we would want people to voluntarily go and get back to their own country. This is something that the 1951 convention doesn't really talk about in detail. So by having a domestic law, India will be able to incorporate their own rules on voluntary repatriation. This is something India has always done. India, through the bilateral treaties, they have had a repatriation treaty with Bangladesh. They've had a similar treaty with Sri Lanka, right? Now, they would move away from a regime of charity to a regime of rights. See, in UPSC, when a question like this is asked, when they are asking you, and this is going to be a very pertinent question, UPSC mains में कभी भी ये question आ सकता है कि why does India need a domestic refugee law? Or why is India not a signatory to the 1951 convention when India has done so much for refugees? So these points are something that is going to give you the marks. These points are something that is going to show the acumen that you have. Because when you write something like this, that India needs to move away from a regime of charity to a regime of rights, you're telling them that India has an ad hoc policy. It's a case-by-case policy. But because it's a case-by-case policy, the nature of rights keeps shifting. So now you want India to move away from a regime of charity to a regime of rights. Right? So when you write an answer like this, you're bound to get a lot more marks than a person who has no idea what this means. Right? So in this case, what does it mean? What does it mean to have a regime of charity change into a regime of rights? It means that, see, the constitution does say that everyone will be treated on par as an alien. But if you look at the ground realities, a refugee who's escaping prosecution versus a migrant who has come back for any other stress, they might not be at the same level, be it economically, socially, or even emotionally. So in that case, India needs to have a right where it is treating refugees differently than it is treating migrants. Right? Even though the constitution put them on par, the bar of the refugees might be a lot lower when it comes to their own economic abilities, their own mental stabilities, and their own trauma that they have faced because of prosecution. And because of that, if you have a domestic law, if you have a regime that provides you rights, all these rights that are being provided to a refugee will ensure that a lot more is done for their own humanitarian help. Right? Then it talks about duties of the refugee. Now, for example, if you have set a domestic policy, you've set up a domestic policy for refugees, just the way you have your citizens and your citizens have certain duties towards the constitution, towards the country, India. Similarly, there should be a number of duties that are outlined for refugees. These refugees, inherently not being Indians, might not be enshrined to the same fundamental duties that the constitution has for its own citizens. But then we can ascribe certain number of duties to the refugees. By doing so, we will be in a position where we can say कि आपकी ये duties हैं as a refugee, and if you go beyond these duties, if you don't abide by certain duties, then your refugee status can be taken away. By doing so, you are also regulating these refugees into assimilating into our own political structure. You give them their duties, our citizens have their own duties, and by doing this, the rights are creating harmony in itself, right? And finally, the most important thing here is that we know that India has been working towards a permanent seat in the UNSC. We also know that the refugee rights is a very big issue when it comes to the international law. I mean, imagine in the international law there are two main customary laws. Customary law. I'll tell you what customary law means. A customary international law. International customary law means that doesn't matter if a party is signatory to that convention. Doesn't matter if a party is signatory to a convention giving effect to that law. Customary law means no matter if you sign the convention or not, it is going to be followed. So one customary law is non-refoulement. The other customary law being that the heads of states are given immunity when they visit a different state, right? But can you imagine the fact that non-refoulement itself is a customary law? So when India has made a domestic refugee law where they have spoken about something close to non-refoulement and they've spoken about refugee rights itself, it really strengthens India's bid for the permanent seat in UNSC, right? In India, already having done so much for refugees, will now tomorrow be able to flaunt that we not only have done so much for refugees, we also have refugees' rights being enshrined by the legislation we've made in our domestic law, right? And these 7 reasons are very important and pertinent reasons towards India getting a domestic refugee law. And this concludes our discussion on refugee rights. Now, in this video and the last video, we've already covered everything that is to be covered in the refugee rights. Now, in the light of this video, I would want you to revisit all the sort of news that you have come across about refugees in the last 6 months. Because remember, the prelims is coming. So for having a holistic understanding, after you've understood this refugee rights, it'll be better if you go ahead, read those news from this perspective. You'll be amazed when, after having this understanding, when you read about refugee rights, especially in news, you'll be able to understand the nuances of it. And I hope that's exactly where you have reached. I hope that you've understood what refugee rights are, and you will be stay tuned for the next video when we talk about privacy rights. So thank you so much. Thank you for tuning in, and I'll see you in the next video. Bye-bye.